Documents. 14. The other hard drive or PDF file consisted of a Cellebrite extraction of cell phone messages between the appellant and Casey. The page length was unknown but voluminous. C. Trial defense counsel reviewed the digital extraction. Trial defense counsel performed keyword searches, reviewed it separately with the appellant to identify what was important. A deep dive but not a word for word of all applicable and reasonably related content. D. Mr. Culp found the substantive value of the extraction was in confronting the witness with contradictions or refreshing the witness' memory, but not in admitting the document. Strategically, trial defense counsel did not want to admit the entirety of the cell extraction because counsel did not want to turn over the complete document to the government due to some number of messages viewed as prejudicial, not favorable to the appellant. Casey's personal documents were not viewed as terribly relevant, with few documents applicable to the trial defense strategy, i.e., unemployment documentation. E. Mr. Culp did not believe the questions he asked in court about messages within the cell extraction would trigger a discovery obligation because he did not show or admit a specific message. At no time did the government request discovery of such messages. F. Mr. Conway consulted a defense expert on the content of appellant's messages and his up-down diagnosis. G. Capberry printed numerous messages between the appellant and Casey in preparation for use at trial. H. Mr. Culp utilized a binder of messages at trial. Witnesses interviewed. I. Trial defense counsel did not interview Ms. Plaskett, Officer Berger or Agent Green. J. Trial defense counsel did not believe Ms. Plaskett had relevant information, based on appellant's account, and would not be beneficial to the case. Counsel viewed a witness observing appellant being nice in the hospital was not probative of anything. Additionally, counsel found it ineffective to present one witness testifying on Casey's lack of character for truthfulness. K. Trial defense counsel was aware appellant raised an immigration issue earlier in case preparation, but not specifically Officer Berger or Agent Green. Counsel understood the appellant was largely responsible for filing immigration documents, not Casey. Counsel did not believe the immigration officer would provide exculpatory evidence or could damage Casey's credibility. Fact finder's consideration of guilty plea. L. Mr. Conway made the determination alone to request the trial judge consider the appellant's guilty plea during findings. It was not planned. It was an on-the-spot decision based on his favorable opinion of the trial judge, whom he knew to be an academic, competent on the law, capable of intellectually separating the offenses, and in consideration of maintaining goodwill. Counsel described the goodwill gained as acceptance of the 128. Separate from the 120 which did not pop up until 14. Trial defense counsel were sensitive to not breach attorney-client communications during their review.